My pleasure, Lordship. Lordship, if I may kindly be allowed to make a mention to move the unlisted motion, Lordship.
Unlisted motion. Is it urgent?
Lordship,
Okay.
there's an urgency in the matter.
Yes.
Lordship, if this matter can kindly be fixed at 2 p.m., because the conducting council will be appearing through VC from Gauhati.
Let it be 1.
Lordship.
Yes. Yes. Any mentions?
For admission, item number 1.
None appears for the petitioner when the matter is called. Any idea about the settlement?
No,
Because
no.
last occasion they said there's some settlement going on.
I have no information about
None
that.
appears for the petitioner when the matter is called. Learned BP Mrs. Mary is present. List the matter after the puja vacation.
For admission, item number 2.
This is that medical board.
Yes, my lord.
Nothing has come. And PP, where's the PP? Who's appearing in this matter?
Sir Tiba.
Oh, Tiba.
Tiba, sir.
Oh,
My
Where's
lord,
Tiba?
he is like in court number 1.
Okay. We'll just defer it for some time, call after some time. Oh, he's come. Yes, any report
My lord, I have not received.
you have not received?
Yes, my lord. I have already furnished the court order to the authority, but they have not given me any report, my lord. My lord, let the matter be come up after vacation.
6th?
My lord.
First day,
Yes, my lord.
6th.
My lord, since the petitioner is having a hard time and he's
No, but
surviving
what
a
can
big
we
loss.
do? The report has not come, the medical report, and since this is a NDPS case, that is a commercial quantity. Unless the report comes, we cannot do anything.
But my lord,
I can
there
give
will
a
be.
direction to the jail authorities to take care of his health, that's all. For now. For today.
Yes.
Yes, but my lord, his medical officer recommended on 21. It's already 1 month lapse and now a puja vacation. My lord, just praying
1
for a
week
short
only,
interim.
1 week only. Vacation is 1 week only, so we will hear on 6th. Okay. Learned counsel for the petitioner, Mr. Bakrin Chapo is present, as well as Mr. Tiba from Learned PP. So, the medical report of the report from the medical board has not been received till date. Stop. Accordingly, list the matter on 6th October 2025, on which date the learned PP shall produce the report without fail. Stop. In the meantime, since the petitioner is stated to be suffering from internal hemorrhoids, which is not improving, the jail authorities are directed to ensure that the petitioner receives proper medical attention till the next date. So, list on 6, copy of this order may be furnished to the learned PP.
My lord, if you may kindly direct NHIK also to expedite. If not, if after 1 week, if they don't see it again, it can go on extending.
It is also made clear before that fixing, it is also made clear that the Managing Director, Naga Hospital Authority, shall submit the report without fail on 6th. Yes.
Much obliged.
For admission, item number 3.
May I please, my lord? Before I proceed to court, item 3, my lord, court 1 has sent me to this honorable court to make an unlisted motion, my lord. There is extreme urgency in the case because there were 9 bidders and all of us submitted defective technical bids and qualifications because this is perhaps the first time or like that where the MORT's tender bid has been made through the state PWD. So we were not allowed to rectify our defective documents.
Okay, at one.
My lord,
Give
my lord,
your slip.
my lord. I am deeply obliged.
For orders, item number 4.
Item 3.
Item 3.
Item number 3 for admission.
May it please, Your Ladyship. Your Ladyship, on the last occasion, CD has been called. However, due to inadvertence, a wrong CD has been transmitted, and the concerned IO could not be located in time. So I'm seeking a short time. But however, Your Ladyship, the ground for bail, it's the same. So when there is no change of circumstances, then this court may not interfere. That is also one of my prayer. If Your Ladyship may kindly come to
on the same
page,
ground.
yes, page 32, the last belt application order. Yeah, second para, starting from second para.
Regarding the grounds of arrest.
Yes, that has been taken into account.
Are we taking up the matter today or not? That is
That is. Yes,
we can proceed
So
without
on this
CD.
ground, I'm praying for dismissal of the belt application.
No, but
When
then-
there is no
but then
change in
the court will
circumstances.
have to see the original documents.
That will amount to reappreciating the matter which has already been settled, and
No, but-
this court will, that will amount to the court sitting.
But Article 22(1) ground, that can
So,
be
Your
taken
Lord-
at any time.
Your Ladyship, that has been taken care of,
That's-
and it will
Otherwise-
amount to appeal jurisdiction. Yes. Your Ladyship may kindly appreciate, and it is a settled principle that when there is no change in circumstances, the successive bail application cannot be entertained. That was the Supreme Court ruling.
Okay, we'll examine on 6th. 6th, you can get it.
Let it be
Seventh.
7th is Wednesday, so Tuesday. Let it be Thursday.
Otherwise, the grounds of arrest I have annexed in my bail application as well.
That will amount to the court exercising appeal jurisdiction.
We'll
Nine.
hear you on that.
9.
Not 7th.
Not 7, I have some fixed matters, so, yes.
Bernard PP, MS Mary submits that she has not yet received the updated case diary and prays for listing the matter on 9th October.
Yes.
Learned counsel for the petitioner is present. So list on 9th October, on which date the Bernard PP shall produce the case diary without fail.
I'm deeply
Obliged, Your
obliged.
Ladyship.
For orders, item number 4.
May I please, Your Lordship?
Yes.
Lordship, I'm appearing on behalf of Bian Sharma, Your Lordship. There's some personal difficulty today, Your Lordship. If 3 weeks' time may be granted, Your Lordship, to file their objection.
Sharma is for the
Claimant.
respondent. Oh, claimant.
Yes, Lordship. Respondent number 1,
Respondent 1.
Lordship. So,
And respondent 2 is the driver,
Lordship.
owner, vehicle owner. Because respondent 2 service is not complete.
Lordship.
Okay. Petitioner?
No, I'm not aware, Lordship.
Learned counsel for the appellant is not present. Stop. Learned counsel, such and such, appearing for B.N. Sharma, the learned counsel for the respondent number 1, prays for how much time?
3 weeks time, Your Lordship, to file
2
objection.
weeks time to file the objection in the IA. Stop. Prayer is allowed. List after 3 weeks. Stop. In the meantime, the registry shall update the 23/9. Shall give update regarding the service on respondent number 2. So list after 3 weeks.
Much obliged, Your Lordship.
For orders, item number 5.
Your Honor, my name is Mudassir Asad, Public Prosecutor, appearing for the respondent number 1 to 4.
Okay.
Your Honor, we need 2 weeks time to file reply.
2 weeks.
Yes, Your Honor. Your Honor, if you kindly fix the date of 9th or 10th of October, because
We'll fix it on 9th.
Your Ladyship, I'm appearing for respondent number 6, HDFC Bank.
Okay.
I need 4 weeks time, my lord, to file my reply. Can it be on 29th of October?
29th October then?
Yes, Ladyship.
9th October. Yes, Your Honor.
29th.
29th.
29th. Yeah.
Counsel for the petitioner, MS such and such is present. So learned counsel, please give your name. Such and such is, you are PP?
Yes.
Special PP?
Public Prosecutor
Public
for
prosecutor for respondent number
1 to 4.
1, 2, 3, I think. Oh, 1 to 4 is 1 to 4 is present and has prayed for some time to file his affidavit in opposition. Stop. Learned counsel, Mr. Your name, please.
R. Chakraborty.
R. Chakraborty enters appearance for respondent number 6.
6, Ladyship.
6 and has also prayed for 4 weeks' time to file his affidavit in opposition. Stop. Prayers are allowed. Stop. List the matter on 29th October 2025. Yes.
Must oblige.
Obliged, Your Honor.
For orders, item number 6.
Yes. Anyone entering appearance? Learned counsel
Lordship,
for the petitioner, Ms. Such and such is present. Learned
I'm
counsel,
for respondent number 4.
Mr. Vijimomi enters appearance for respondent number 4. You have filed your power.
Lordship will be filing within this.
This is for respondent number 4 and prays for some time to file his power and affidavit, if so advised. Stop. How much time? 3.
3 weeks time.
List the matter after 3 weeks.
For orders, item number 7.
Service not complete.
Yes, Your Honor. Lordship.
Learned counsel for the petitioner, Mr. Sergeant is present. Office note dated 23/9/2025 indicates that the service report is still awaited in respect of respondent number 1, 5 and 7. Stop. In respect of respondent number 1 and 4, the notice has returned unserved with the remark, open inverted commas, insufficient address, stop, return to sender, close inverted commas. What to do, 1 and 4?
Lordship, some time may be given to.
Ascertain.
Yes.
The learned counsel submits that he may be given some time to ascertain the correct address. Stop. Accordingly, list the matter after 4 weeks.
Lordship.
4 weeks. Yes.
Obliged. in order to participate in the tender process, which I have annexed, that is for performance-based maintenance contract for National Highway, all National Highway 69, from kilometers 125 to 135, under National Highway Division 2, Mohokchung, in the state of Nagaland, for an estimated bid cost of 1,190.46 lakhs. Now, nine bidders participated in the tender process. All of them had defective technical bids and qualifications. Now, in a surreptitious and arbitrary manner, the bid evaluation committee, after the opening of the technical bid, allowed the private respondents 6, 7, and 8 to correct their defects and submit their shortfall documents and qualifications, my lord, which is very much evident from Annexure 12, page 564. This is the last annexure. Page 565 is relevant. 564, the title of the documents by itself, it is evident that minutes of meeting of bid evaluation committee.
Minutes of meeting of bid evaluation committee held on 2nd September, performance-based maintenance contract. Yes, how does it show? Where does it show that they were allowed to?
At 6.2, my lord.
6.2.
Yes, my lord. This is private respondent number 6. In case of bidder so-and-so, the bidder has not submitted an undertaking as mentioned in clause 12.2h of the RFP. However, the committee observed that the bidder has submitted all the required documents in order, and it was opined that the bid of MS so-and-so may be considered as responsive. Now 6.3, this concerns the petitioners. In case of bidder so-and-so, so-and-so, the bidder has not stated that he has enclosed all the necessary formats and documents. However, upon perusal of his tender document, it was observed that most of the formats, so-and-so, so-and-so, have not been provided by the bidder. The committee opined that the bid of MS so-and-so be considered as non-responsive. That means mine was rejected. Now 6.5, my lord. Here also, he was allowed. This is private respondent number 7. In case of bidder so-and-so, it was observed that the road safety auditor proposed by the bidder does not have a road safety audit certificate from approved government agency and hence does not have the required qualification. However, as per the provision of clause 9.1 of the contract agreement, a replacement for the road safety auditor should be proposed by the bidder if the work is awarded to him. Accordingly, the bid of so-and-so is considered as provisionally responsive. Now 6.7, Lordship.
6.7.
This is private respondent number 8. In case of bidder so-and-so, it was observed that the road safety auditor proposed by bidder has a diploma in industrial fire and safety management as against the requirement of road safety audit certificate and hence does not have the required qualification. However, as per the provision of clause 9.1 of the contract agreement, a replacement for the road safety auditor should be proposed by the bidder if the work is awarded to him. Accordingly, the bid of so-and-so is considered as provisionally responsive. Now, my lord, if only one...
Just see, yours is 6.3.
Yes, my lord, 6.3.
So for the others, it is the road safety audit certificate, then
Yes.
one it is undertaking. But in yours, it says annexure 1A, 2, 3, 4, all these, the formats
Yes,
are
my
not
lord.
provided.
Yes, my lord. Now, when such things arises, my lord, normally, ordinarily, after the opening of the technical bids, the defect is not allowed to be rectified. They should have gone for a fresh tender.
Fresh tender.
That issue is well settled in a recent decision.
So all of you had defects.
Yes, passed by the Honorable Supreme Court. I'll be placing only that single judgment in order to... Paragraph 27, my lord. Identical case, my lord. The facts are also very much identical. 27. Thus, the said action of the respondent PCCL in rejecting the technical bid of the appellant on absolutely extraneous ground and accepting the technical bid of the respondent number 8 those submitted in utter non-compliance of the mandatory requirement of Clause 10 of NIT and subsequently calling upon Respondent 8 to furnish the shortfall of documents after opening of technical pit of the bidders was totally arbitrary and illegal. And in Para 38, my Lord, fresh tender have been allowed, was directed by the Honorable Supreme Court, fresh tender process. In the other paragraphs also, how arbitrariness should not be allowed to be crept into in government contracts, how Article 14 should not be violated by the government agencies while awarding government contracts. All this have been discussed by the Honorable Supreme Court. However, in order to save time, my Lord.
Yes, yes. And so you're praying for a fresh tender process?
Yes, my Lord. And, my Lord, the stay of the tender process till the next returnable date, my Lord. Or till the disposal of the instated petition. I have served copies to the Government Council as well as to the respondent number 1, that is the union, this morning. The notice I have enclosed as part of my petition towards the last pages of the petition.
So what is the stage now? Today is?
Now, Lordship, the technical, after the technical pit, financial pit is yet to be opened.
Financial pit, okay.
Yes. And without us, my Lord, they are going ahead with the tender.
Yes. We will issue notice.
Yes, yes.
And I think stay is required at this stage.
Your Ladyship,
The present, yes.
please, page 565, 6.3 is the case of the petitioner. Now, petitioner may please explain Appendix 1A, Annexure 2, Annexure 3, Annexure 4.
That he has not provided the formats, that is what they're saying.
Yes, my Lord.
And in case of this 6.2, there also he has not submitted
Yes.
the undertaking
Yes.
as per clause 12.2 of the RFP.
Yes. In
Then
paragraph
6.5 also, he had not submitted not submitted, but submitted, but it does
He
not
lacks
have
qualification.
a road
Yes.
safety audit certificate.
6.7
and
also
did
lacks
not
qualification.
have the required qualification. 6.7 also,
Lacks
it
qualification.
does not have
Yes,
the
my Lord.
qualification.
6.4, 6.6, this deals with other contractors, other bidders, Lordship. Here also, there was shortfall of documents and qualification. However, like us, like me, they were also not given the privilege to correct the defects.
Okay, where is the NIT?
Annexure 8, my Lord.
Page?
Page 28. It has been issued by the Chief Engineer PWD National Highway Nagaland Kohima. He is also the chairman of the Pit Evaluation Committee.
It is not dated.
It is digitally signed, my Lord, at the bottom of the page.
Okay, okay. 14, no,
23rd May,
23/5.
yes, 2025.
23/5/2025. The present application under Article 226 of the Constitution of India has been preferred by the petitioner. praying for quashing of the impugned minutes of the meeting of bid evaluation committee dated 2/9/2025 and for a direction to initiate the tender process afresh. Stop. Para. Heard Learned Counsel for the petitioner, Mr. Sintianger, as well as Mr. Moa Inchen, Senior Government Advocate, for the respondents number
2 to 5.
2 to 5. And Miss Union is not there.
No one is there
Okay.
for union.
We have served Lordship, however. They have also accepted the notice is already part of the
Stop.
petition.
Who accepted?
Yang Awati.
CGC Yang Awati. Learned CGC, Mr. Yang Awati has accepted notice on behalf of respondent number 1. However, none appears for respondent 1 when the matter is called. Stop. Para. The case of the petitioner is that the petitioners number 2 and 3 are class 1 government registered contractors who entered into a joint bidding agreement for joint venture for participating in the tender process initiated by the Chief Engineer PWD National Highway under bracket Nagaland Kohima vide NIT dated 23/5/2025 for inverted commas performance-based maintenance contract work on NH02/all NH61 from KM 125.000 to KM 135.000, length 10.00 kilometer under NH Division 2, Roman 2, Mukokchung in the state of Nagaland for an estimated bid cost of 1190.46 lakhs. Stop. Para. According to the petitioner, 9 bidders participated in the tender and the bid evaluation committee opened the technical bids and found that all the bidders had defective documents/qualifications. Stop. However, in the impugned minutes of the meeting of bid evaluation committee dated 2/9/2025, private respondents number 6, 7 and 8 were allowed to rectify their defects and only the technical bids of and therefore only the technical bids of private respondent number 6, 7 and 8 were held responsive and qualified. Stop. Para. The petitioner has contended that after the opening of the technical bids, the private respondents could not have been allowed to rectify the defects, and such rectification is arbitrary and illegal. Stop. The petitioner has relied on the case of Panchidar Construction Private Limited versus Bharat Coking Coal Limited and others, reported in, you just see from here, reported in 2024 10 SCC 273, wherein the Honorable Supreme Court had stated that that allowing rectification in defective tender documents after the opening of the technical bids was arbitrary and illegal. Stop. Para. Issue notice returnable within 4 weeks. The petitioner shall take steps for service on the respondents numbers 6, 7 and 8 by registered post as well as usual process within 3 working days from today. Stop. In the interim, the impugned Your prayer,
It is at page 13, my lord. My main prayer is at
impugned minutes of the meeting of bid evaluation committee dated 2/9/2025 shall remain suspended,
as well as the tender process, my lord.
as well as the entire tender process till the next returnable date.
Deeply obliged, my lord.
Extra copies, you need extra copies. Extra copies of the
Within 3 working days, my
petition
lord.
shall be submitted by the petitioner to the senior government advocate within 3 working days.
I'm deeply obliged.
For motion from the supplementary clause list, item number 9, criminal petition 34 of 2025.
Yes, yes.
This is an application under section 528 of BNSS Act Lordship, wherein petitioner has challenged the impugned FIR dated 22/9. Impugned
22/9 or 21/7?
Your Lordship, Golaghat having Diphupar PS case number 41 of 2024 Lordship, FIR dated 21/7/2024 Lordship. Annexer 1 Lordship, FIR page number 16 Lordship.
Yes.
So Lordship, may I please to read this FIR Lordship?
Yes, please read.
With veneration, I have the honor to state that Mr. Ananta Burwa gave 1 JCB to me and my friend Akaito Yapto and J. Akao Yapto, bearing registration number so that is interest, bearing number so on higher basis, and accordingly I have paid him 8 lakhs rupees for 3 years. However, as per the court order of Golaghat Magistrate, the said vehicle JCB was seized and taken away by Assam police as Mr. Ananta Borua was not the actual owner of the said vehicle JCB. In this connection, Mr. Ananta Borua went into hiding and evade arrest. In due course of time, I was able to contact him, his mobile number so and request him to repay back the money which he owe me, to which he promised to repay back my money 8 lakhs and asked for some more time in order to arrange the said amount of money. But till date, he has failed to repay back the said amount to me, and now he has been hiding whereabouts. He is not known. His 2 mobile number mentioned above is still active. Therefore, case has been registered and having Diphupar PS case number so and investigation is going on, Your Lordship. In this regard, Lordship, previous occasion I have filed an anticipated bail application, but accordingly, interim protection was granted to me, and thereafter directed to me appear before this court. But subsequent stage, due to some reason I have mentioned in my petition, Lordship, I am unable to appear. But subsequent stage, Lordship, I have withdrawn the safe bail application, Lordship, with liberty, Lordship. Now, Lordship, the question is that, Lordship, the present case, Lordship, has been filed, Lordship, that is on 21/7/2024, Lordship. So, Lordship, arising out of the same cause of action, Lordship, one another case has been filed by the another informal, Lordship, and same has been pending at Golaghat, Lordship, Learned Chief Judicial Magistrate Golaghat in the district of Golaghat, Assam, Lordship, having Golaghat PS case number 944/19 under section 420/406 of IPC. So, Lordship,
With regard to the same matter,
almost same, Lordship. Only because of that, Lordship, very interestingly, can you go to the FIR, Lordship?
where is that?
Page number 36, Lordship. Page number 36, that is the FIR. Page number 36 and relevant portion, Lordship, page number 44. May I please to read this FIR, Lordship? Humble submission is that I would like to inform you that on 17/6/2019, through a notary of the Golaghat Bar Association, I entered into an agreement where accused number 3 and 4 had taken 2 proclaim machines on hire basis for working purpose. On basis of the agreement, they paid 2,50,000 for each machine, total amount of rupees 5 lakhs as advance first month, but later they did not pay. Also, they had sent back the drivers of the machine. Now, neither pay money nor give back the car. On the other hand, accused number 1 and 2 had taken JCB and proclaimed total number of 3. Accused number 2 is Ananta Borua, Your Lordship, in these cases. For working purpose through notary agreement, on basis of the agreement, they had paid amount of rupees 2,70,000, 2 number of JCB and 2,60,000 for the proclaim as the advance of the first month, but when I asked to pay money for the next month, as per the agreement, they had paid 1 lakh for the JCB. The remaining amount has not been paid as on today. Moreover, they sent back the drivers of the 3 vehicles by threatening and scolding. Other side, if I want to go to the vehicle, they do not allow me. Do not keep contact with us in turns, threaten me. Therefore, request before your necessary action, accuse and rescue my vehicle and return to me. In this regard, Lordship, another case has been registered. That is interestingly the same vehicle, Lordship. That is vehicle number WB73D4135 JCB, Lordship. Other hand, the impune FIR, Lordship, that is FIR Annexer 1, Lordship, page number 16, Lordship. That is the same vehicle, Lordship.
Page 16 is the same vehicle.
Yeah, vehicle number WB73D4135. So, Lordship, this is the same vehicle, Lordship. And Lordship, this present case, impugn case has been filed. That is 21/7/2024, Lordship. After 5 years back, Lordship. And Lordship, although he has mentioned here that the vehicle has been hired basis. So, Lordship, previous occasion, Lordship, that is categorically mentioned in the police report. Subsequent stage, Lordship, the police personnel has made investigation. Thereafter seized the vehicle, Lordship. And again, Lordship, the police personnel has submitted the final report, Lordship. That is the Annexer 9, page number 50, Lordship. That is the final report prepared by the investigation officer in connection with the Golaghat PS case number, Lordship. And final report has been prepared, that is having number 568 dated 31/12/2020, Lordship. Herein categorically mentioned that, Lordship, that matter has been a purely in civil nature and agreement has been made out. Therefore, Lordship, the report has been prepared by the investigation officer, and presently this case has been pending before the learned Chief Judicial Magistrate Golaghat, Lordship. As record reveals that, Lordship, matter has been made final report. So, arising out of the same case, Lordship, one of the co-accused, Lordship, who also moved to the before the Supreme Court, before the High Court, Lordship, Annexer 8, page number 48, Lordship. That is the co-accused arising out of the Golaghat PS. May I please to read this FIR, Lordship? Order, Lordship. Lordship. Yes. In this case, Lordship, under section so-and-so, seeking clearance bail by the petitioner, namely so-and-so, apprehending arrest in connection with Golaghat PS case number so-and-so, corresponding so-and-so, registered under section so-and-so of IPC, have perused the petition, including the FIR and the document annexed therewith. The case diary has also been perused. Heard Mr. So-and-so learned counsel appearing for the petitioner, Mr. So-and-so learned additional public prosecutor. The case of the informant is that petitioner has taken proclaimed message and JCB from him on rented basis and rent for a few months have been paid. Thereafter, they have stopped payment of the rent and have also not returned the proclaimed machine and the JCB. It has been found that there is an agreement between the parties. So, Lordship, when I have taken the vehicle like JCB and one under the proclaim which has been mentioned in the impugn order, impugn FIR itself, same has been taken on rent basis, Lordship. Agreement has been made. Thereafter, Lordship, another agreement I have made with the present informant, Lordship, arising out of the Dipupar PS case number. Therefore, Lordship, agreement between the parties for later out the proclaim machine and JCB on rental basis. Non-payment of the rent of the aforesaid vehicle is the core issue between the parties, resulting in filing of this FIR. Since the vehicle were given on rent on the basis of an agreement, the matter appears to be civil nature. On the other hand, petitioner is availing interim protection. He has appeared before the investigation police officer in accordance with order granting interim PLS bail to him. His statement has already been recorded and has not misused the liberty granted to him. Liberty on so and so, bail petition has been its absolute lordship. So lordship, in this case lordship, I also undergone to the judicial custody thereafter lordship by the intervention of the Honorable District and Session Judge Golaghat lordship. I was also released on bail lordship. Then thereafter cooperate with the investigation officer arising out of the Dipupar PS case number. So lordship, in such circumstances, lordship, the present impugned FIR has been lodged by one another informant, that is Akaito Yapto and another one lordship, stating that lordship, I have given the vehicle on hire basis lordship, but only after 5 years back lordship. Nowhere mention what is the delay of the arising delay to lodging the present FIR lordship. Very interestingly, if lordship, I have given the said vehicle to him on basis of such and such agreement has been made out between the parties lordship, informant and the accused itself lordship, but there is a civil nature lordship. So I have no such intention to seat them lordship. The vehicle which I have given to them lordship, but same has been recovered only after in the intervention of the police personnel of the Golaghat PS police station arising out of the Golaghat police station case to law. Yes, Your Lordship. In this regard, Lordship, the police report has already been prepared wherein categorically mentioned that, Your
So this
Lordship.
means that for the same vehicle, same JCB, you had entered into an agreement with different people, isn't it?
Your Lordship, the initially
Kolkata
Lordship,
also in Dimapur also for the same JCB.
Your Lordship, first occasion Lordship, before 5 years ago Lordship, I have supplied the state vehicle Lordship from another informant Lordship. Then thereafter Lordship, I made an agreement with the present informant arising out of the Dipupar PS case number. When Lordship, the agreement is going on and Mr. Akaito Yapto has operated the said vehicle, but during the course of time Lordship, the one another case has been filed by the actual owner of the vehicle lordship against me lordship, that the vehicle is under custody of the Akaito Yapto lordship at Nagaland. Then thereafter intervention of the police personnel lordship, vehicle has been recovered. The said vehicle has been recovered prior 5 years ago lordship, in the year of 2019 lordship.
Where is the vehicle now? With the owner?
Yes, Lordship, the vehicle has already been returned, Lordship, and vehicle has been returned and police report has been prepared by the investigation officer, Lordship, arising out of the default.
Then what about the payment which you are due to, which you have to pay this?
If Lordship, if there is a remaining payment, there is a agreement between us, Lordship, there is enough right to file a civil suit before the appropriate jurisdiction. There is a civil nature, Your Lordship.
Where is the agreement? Where is the agreement?
Lordship, Your Lordship, agreement is not available with me as of now, Your Lordship. As being the agreement is under custody of the informant itself, Lordship. In this case, Lordship, I have made an party.
No, since you are a party to the agreement, the copy must be with you also.
Yes, Your Lordship, the agreement copy is not with me. In this case, Lordship, now, Lordship, we made a party, the Akaito Yapto, the informant of the instant case, Lordship. So, Lordship, if Your Lordship call for records from the concerned police station, then it will be crystal clear, Lordship. It will be disclosed, Lordship. So nothing else, Lordship. Then what to do? Only if after sublet the vehicle to the present informant lordship, and same has been recovered only by the intervention of the police personnel of the Golaghat police station. They have to, how to do lordship? What is my rule lordship? If I have remaining dues to him lordship.
Who's appearing? You're appearing. Yes, we will issue notice.
Lordship.
And we'll have to see whether an agreement is there. If an agreement is there between the parties, then they will have to go for execution of that agreement only. If any payment is left, any payment is
Till then in time may can be granted. That is my
this present application under section 528 of the BNSS has been filed by the present petitioner, praying for quashing and setting aside of the FIR dated 21/7/2024 and the investigation of the Dipupar PS case number 41/2024 under section 316 clause 2 2/318 clause 4 of the BNS. Stop. Heard learned counsel for the petitioner. Mr. Your name?
Ananta Barua, Your Lordship. Ananta Barua.
A. Barua. No, your name, your
Mintu Saikia.
counsel.
Mintu Saikia, Lordship, and his
Counsel for the petitioner, Mr. Mintu Saikia, as well as the learned public prosecutor, Mr. Vij Momi, for the respondent number 1. Stop. The submission of the case of the petitioner is that the present FIR, the impugned FIR, as well as the GR case number 41 of 2024 arises out of an agreement executed between the petitioner and the respondent's number, petitioner and the respondent's number 3, respondent number 3, for taking 2 JCB machines and 1 Falkland machine. No, sorry. In the present one, it is only 1 Falkland. What is that? For taking 1 JCB machine on hire basis. Stop. It is the submission of the learned counsel that the case is purely civil in nature, and if at all there is any breach of the agreement, the respondent number 3 has to approach the civil court for remedy, as there are no criminal ingredients in the present case. Stop. Issue notice returnable within 4 weeks. Stop. The petitioner shall take steps for. Why have you made the state of Assam also a party?
Lordship, as because Lordship, one another case has been presently pending in the Golaghat.
No, but in the present case, you are impugning only the Tipupar PS FIR. You are not impugning the other case. There's no need actually. The petitioner shall take steps for service on the respondent number 3 by registered post, as well as usual process within 3 working days. So, in the interim, the investigation process in the Tipupar PS case number 41/2024 under section 316 clause 2/341 IPC shall remain state till the next returnable date. It's after 4 weeks.
For motion from the supplementary cause list, item number 3.
May it please, my Lordship.
Yes.
Lordship, the petitioners have filed with petition civil number 162/2025 before this honorable court. While the case is pending, Lordship, here, what has happened is the case of the petitioner is confined only to the petitioner, the respondent 1/6 to 171 were appointed on 28/8/12 and 31/7/2015 in 2 batches. Now, the cabinet by decision dated 13/7/12 gave retrospective regularization to the respondents on 1/4/2011 before prior to their appointment. So the present petitioners, 52 petitioners, challenge only that portion where they were given retrospective regularization. And they were in the seniority list, impugned final seniority list, they were placed above the petitioners who were appointed in 1997 to 2007 in between. So we challenge that regarding only the impugned Seniority, impugn cabinet decision pertaining to that giving retrospective regularization on 1/4/2011. In spite of that, Lordship, what has happened is some elements, as Lordship is aware, overground, underground, they started campaigning in public domain and misled the respondents that the petitioners have filed a case to terminate their service. And so, with that kind of campaigning, the petitioners are being harassed, scolded at, and being threatened. So, just, Lordship, we are praying before this Honorable Court, just my prayer is at page 16. Just a
But was there any interim order?
interim,
Was there any interim order in this WPC 162?
no.
Then in that case, unless it is to clarify an order which this court has passed.
It's not about that.
It is not about that.
It's not about that. We are not coming to that case. It's just that if my Lordship will kindly see page 16, just before this Honorable Court, the prayer.
So you want to include this in your petition?
No, just a declaration that the petitioner case is confined to and limited to only fixing effective date of regularization seniority with effect from 1/4/2011.
That's why now I'm wondering, because if there is an interim order and you want the court to clarify on that interim order or modify something, then it's okay, the court can do it. Or if you want to put this in your petition, if you want to insert this in your petition, that also by way of amendment, it can be allowed.
Okay.
But how to put this, that is the thing. Isn't it?
Lordship,
What do you say?
since the petitioner has been pursuing since yesterday, what I observed is that now petitioner is seeking one order that their challenges, their allegation in the main petition is
Limited to only.
limited to that against cabinet memo. So they want to obtain that order, that order should clearly specify that the prayer of the petitioner is not against the private respondent, but it is they are assailing the cabinet memo saying such.
Because
Me considering the situation
Only that-
outside the court, I think
Some
it
have-
seems, the other respondent, they have a
They have some
impression,
misconception.
misconception
Yes.
that by filing this, the petitioner is trying to oust their terminate their
Yeah,
service.
that- because
So
of that
in order to qualify the other respondent, I think the petitioner is seeking the
Only that,
honorable
only
court
that.
to
Because
obtain an order that their focus is not against the private respondent.
not private respondent, only that to clarify.
Yes.
We are only for the seniority, otherwise nothing else. And even in our petition, it is.
Okay, so it has to be a fresh order.
Yeah, fresh
Yes,
order.
that's all. That's just
IA will
clarification.
be disposed of by that order.
Because-
IA can be disposed of and
Yes.
then
Yes, that's all. Because some of them are going to withdraw already, the petitioners, because
that
they've
is-
been
that
threatened.
is again besides the point.
Yes,
Anyway,
yes.
in the present IA filed by the petitioners in WPC 162/2025, the petitioners are praying for the declaration of this court to the by this court to the extent that the petitioner's case is confined only to giving effective date of petitioners, you are against this, isn't it?
Yes, only
Petitioner's
this,
case
only this.
is only against giving effective date of regularization / seniority with effect from 1/4/2011. And consequently, placing the respondents above the petitioners in the impugned final seniority list of 2022. And that challenge is not made to any other issue in the to any other order or any other order in the writ petition. heard learned counsel for the petitioner, Ms. Z. Momi, and also Mr. M. Tim Song, learned additional AG for the state respondents, who has no objection to the said prayer. Stop. Therefore, this IA is disposed of with the clarification that the applicants slash petitioners in WPC 162/2025 have challenged the impugned cabinet memo dated 25/6/2012 and the impugned office memorandum dated 13/7/2012, confining only to the giving of retrospective regularization / seniority to the respondent number 6 to 176 with effect from 1/4/2011. And there is no other challenge made to any other order.
Or to terminate their service, Lordship, because that is being confused.
Or for terminating the service of the private respondents number 6 to 176.
Lordship.
Petition stands disposed with the above clarification. Yes.
Obliged, Lordship.
Number doesn't matter.
Now they can see.